What are the methods? Signature, notice, and previous cause of dealing. So class, there are so many cases here. So this one, a lot of cases. For example, Strange and Broker for signature. For notice, you have Oli and Marlborough. Right? You have Compton. You have many cases here in this segment. Now, if you cannot incorporate class, the rest becomes inconsequential. But for exam purposes, please go through quickly. Construction class. This one, the clause must be properly worded to cover the loss. And here, very important case is photo production and securing call. Right? The third one, unusual factors. This one will neutralize the exemption. Once you have an unusual factor like misrep, it will neutralize the exemption clause. What's the case law? Curtis, Mrs. Curtis and chemical pleading. Right, that's the last one is extremely important. Please know the Unfair Contract Terms Act, Section 2(1). You cannot put a clause in your contract that says you are not responsible for negligence resulting in personal injury or death. So Section 2(1) is critical. So Section 2(1) is for personal injury or death. Section 2, subsection 2 is for other kinds of damage. You can put in an exemption if it satisfies the test of reasonableness. Please put a side note. So Section 2(1), personal injury, death arising from negligence, answer is no, you can't avoid. But Section 2(2), other kinds of damage, property and so on, you can exempt yourself from liability if you can show reasonableness. And that depends on the bargaining strength of the parties. Right? Right, class, this segment. Next lecture. Class, discharge by contract, not a major area. Alright, so please go back and look at it. It's now been tested before, except for this last bit, frustration. Go back and read the slides. What is frustration? Alright? Contract becomes impossible, illegal to perform, so radically different because there's something beyond the control of the parties. Please go back and read it. Alright? Okay? Then class, performance has not been tested, breach not so much. Right. Let's go on to remedies class. This came out last year, remedies for breach, this one. What must you prove? First, you must prove what is called causation. Can you put down here what is called the but-for test? So under causation, you must prove the but-for test. Class, but-for test means you are showing the connection between the defendant and the breach. That's all. Right? So here you must establish the but-for test. Connect the defendant to the breach. Once you have done that, you must establish the next stage called remoteness. This one is very important. Hadley and Baxendale. This part is important. You must ask yourself, is it a normal loss or is it an exceptional loss? If it's a normal loss, the defendant is deemed to know. You take full responsibility, You take full responsibility. You are deemed to know. For example, day-to-day losses, normal profits, all that will come at a normal loss. You are deemed to know. You can't escape liability. Exceptional loss, you are responsible only if you actually know of the potential for this loss when the contract is made. So there are two different levels. Normal, everybody is deemed to know. You are liable. Example, day to day. Exceptional loss, something which you are only liable for if you have actual knowledge of the potential for this loss when you enter into contract. Right? Now, once you go through these stages, class, the last stage is mitigation. You must take steps to reduce your loss. All reasonable steps. Right? So for this lecture class, the area of focus is this second segment, remedies for breach. Right, sale of goods. Class, the one about sale of goods, the relevant sections that you need to zoom into are section 13, 14.2 and 14.3 only for sale of goods. I put down all the sections here, alright, but you can see the second segment class. Description is section 13. This one is satisfactory quality is 14.2. Fitness for purpose is 14 subsection 3. These are the three sections you must look at. Alright? For 13, 14 subsection 2, 14 subsection 3. The rest, right? Section 12, section 15 don't bother. Right? It's normally not tested. Right, so goods must be as described, they must be of satisfactory quality, they must be fit for the purpose. Please go through the requirements of the section. It's a long lecture class. Then please know the exemption clauses. Right? Exemption clauses. What's the impact? If it's consumer sale, the exemption is useless. This is section 6 bracket 2. You can put a side note. This one is 6 bracket 2. EC is void, is 6 bracket 2. Right? The last one is non-consumer sale. That means B2B. This one is 6 bracket 3. Test of reasonableness. Right? So sometimes they have a question on consumer protection. How is a consumer protected? They talk about Unfair Contract Terms Act, Sale of Goods Act, and so on. Right? Now here, there is also some reference to the Fair Trading Act. Please go back and look at the textbook. Unfair practices. If you try to cheat customers, mislead or deceive them, then this section becomes relevant as well. Now the court that enforces this unfair practice, the last order, that takes orders against unfair practices will be the Small Claims Tribunal. So please go back and read this. So Small Claims Tribunal is the court that gives remedies against unfair practices. Right? Now, before you employ the Sale of Goods Act, before you use this, please make sure that it's strictly a sale of goods. Do not use sale of goods when services are concerned. So in the exam, don't get this completely wrong by saying, oh, this guy is not performing his service properly. Under the Sale of Goods Act, then you know you're wrong. Because this one is strictly goods. What are goods? Tangible goods. No element of service is involved, but class tangible goods. Either future, present, whatever. Negligence class. This one is the one that I think you can bank on. You'll come out in the exam. One of the two questions I'm expecting it to be negligence. Last year, the first question was negligence. The very first question in the exam. Now here there are two parts. There are two parts. The first part is negligent actions. Right? The first part is negligence actions. The second part is negligent statements. That is wrong advice. Right, let's go to the elements for negligent actions. Number one, there must be a duty of care. Alright? What must you prove? Factual foreseeability. Alright? This one class, assume it's proven. Now go on. Proximity class is the legal relationship between the parties. For example, customer and manufacturer, consumer and manufacturer, right? Employer and employee, for example. So some relationship would be here. Right? Now, if there is a secondary victim class, don't forget about nervous shock. Secondary victim is someone who is not directly hit by the impact, but who suffers from nervous shock as a consequence of witnessing the accident. So this may not come on a class, but if you notice there is somebody else who's related who suffers nervous shock, then this part will become relevant. Right. What is policy, class? Policy is a negating factor. In other words, you must simply say there is no policy that avoids the duty. You can say this with some confidence, class, unless you notice that the liability is open-ended, indefinite, everybody can claim when policy becomes an issue. Otherwise, class, the answer will be policy is generally not something that's relevant. Breach. Look at the standard. There are 4 elements. Level of skill is the professionalism level, how professional the person is. How likely is the injury, how serious is the injury, and what are the costs of prevention. So remember some of the pointers I mentioned last week. High cost, high risk, take the precaution. Low cost, very high risk, take the precaution. Plus the only problem will be if you have very negligible risk but very high cost. The case is Latimer, right? The case of Latimer, then you don't have to take precautions. Right, res ipsa loquitur. Please do not use this very loosely. This only applies for the benefit of the plaintiff when the accident is so clear it could not have happened unless the defendant is callous. Example, falling objects, class falling objects. Things that go out of control, then you apply res ipsa. Otherwise, do not apply res ipsa. Resulting damage, class, please remember the but-for test. Same thing, huh? The case law which we just discussed last week is Barnett and Chelsea. Right? Where the but-for failed. Class, remoteness is the wagon mount case. Right? So go through the case again. Class, defenses, the one that is very likely to come out could be contributory negligence. You as the plaintiff is also callous. Right? Very likely. So both parties are callous, damages will be reduced. Now, assumption of risk, class, do not apply this too casually. Yeah? Assumption of risk. This means you know of the risk and you take the risk with full knowledge. This will happen for hazardous sports activities and so on. Otherwise, do not apply this. Unfair Contract Terms Act, you only need to go back and review Section 2. That's all, nothing else. Under Section 2.1, you cannot avoid liability for damage or for injury if you have been negligent. Right? Class remedy will be compensation, monetary damages. Right. This one, class, is now the second set. Negligent misstatement. This means that you have given incorrect advice. Again, you prove duty of care, factual foreseeability, proximity. Here, class, it is special relationship. The relevant case law here is a case called Hadley-Byrne. You have it in your slides. Policy, class, again, if it's open-ended liability and so on, then you discuss policy. For breach, you discuss standard, but only one area you must focus on is the person who gives the advice professional. Then resulting damage, class, remedy will be again damages. Right? So please check your question. Is it about giving wrong advice? Or is it about doing something wrong? If it's doing something wrong, it's this segment. If it's wrong advice, it is this segment. Vicarious liability, very important. Class, this is to be used whenever there is an employer-employee scenario. So the moment you notice an employee in the scenario, you must remember the employer will be vicariously liable. Right? So an employer becomes vicariously liable. What are the conditions? He must be an employee. He must do some thought in the course of his employment, basically. Alright? So please go back and look at Kokeki, Summins case and so on, which we did last week. Right? Right, class? That is the coverage for exam. Okay? It's a long list, huh? Right? Long list. And there are many cases. Class, when I came to vitiating factors, I cut down the cases because I think you have to really go back and read. There are lots of cases, right? Okay, so please go back and read them. Right, is there anybody who would like me to scroll up or scroll down? Yes, up or down? This one? Next.
可能啊，他讲可能会再考，不然就是在 MCQ 里面。可能在 MCQ 啊，他放那个 law 在里面，让人去选。
Okay.
他没有 upload 对不对？
我也是需要再文档。
Right. Vitiating factors. Terms. Now this one I don't think is a very major area. This chart is very easy. Sale of goods, yes. Sale of goods class, this portion here, section 13 and 14. That's all. 42 and 43. And the last one I think is critical. So you can see the asterisk here. This one is very, very likely to come on the exam. Okay. So class, from this we move on to now last semester's exam paper. This is last sem's exam paper. It was supposed to be uploaded. Class, it has not been uploaded. Okay? I can't tell you why. Right? Because I'm not there, so I'm here.
Last semester.
Normally when we say upload, we will upload. But here, this one, you can see how long it's a question. And it's about negligence. Hold on. It's a very long question and it's very difficult for me to put it up all at one go. So what I'll do is I'll cut down some spacing